This video is about Rule 65, and this is your Certiorari, Prohibition, and Mandamus, and this is already the part 4 or the last part of our discussion about Rule 65. So ang naging guide natin sa ating discussion is the syllabus issued by the Supreme Court. So we are done with the definitions and distinctions requisites. When is your petition for Mandamus, Prohibition, and Certiorari proper? The injunctive relief. We distinguished also Rule 65 from Rule 45 and from your judicial power. And we correlate our discussion to the exception to the filing of motion for reconsideration before filing of your petition. So in this video, i-discuss na natin yung mga natira. Ang natira is distinguished prohibition from mandamus and injunction. When are you going to file your petition and where? What are the reliefs petitioner is entitled to? The acts or omission of the first level, that is your MTC and RTC in election cases, and the effect of filing an unmeritorious petition. We'll distinguish now injunction from prohibition and mandamus. Take note that your prohibition is not the same as injunction. Magkaiba yan. In fact, in a Supreme Court decision, ano ang sabi ng Korte Suprema? Lawyers, they often make the mistake of confusing prohibition with injunction. Ano nga ba itong injunction? Bakit siya nagiging confusing? Because when you go to your Rule 58, that is your preliminary injunction, ano ang sinasabi ng Section 1? It is an order that is granted at any stage of an action or proceeding but prior to the judgment or final order. And in that order, you require a party, a court, agency, or a person to refrain from a particular act or acts, and that is called your preliminary prohibitory injunction. Diba, pag tiningnan mo siya, more or less similar siya sa prohibition. And if you will read further, it can also require the performance of a particular act or acts, in which case it shall be known as preliminary mandatory injunction. And if you're going to compare that to mandamus, more or less they have the same output. That is why we need to distinguish or to differentiate injunction from prohibition and mandamus. Take note that your injunction is an ordinary civil action. Sinabi natin that there are two kinds of civil action, and that is special civil action and ordinary civil action. Injunction is an ordinary civil action that is governed by Rule 58. How about your prohibition and mandamus? They are special civil action under Rule 65. And if you're going to file your prohibition and mandamus, they are always a main action. Whereas your injunction, it could be a main action itself or just a provisional remedy in the main action. And who is your respondent in prohibition and mandamus? It is a tribunal. The respondent is either a tribunal, the corporation, board, or officer. In mandamus, exercising ministerial functions. In prohibition, exercising judicial, quasi-judicial, or ministerial functions. How about in injunction? Your injunction is, it could be directed against a party, a court, agency, or person. That is very clear according to your Rule 58, Section 1. But generally, general rule it is directed against a party in the action. Next, what is your ground? In mandamus, your ground is the respondent or the tribunal, corporation, board, or officer or person is unlawfully neglecting the performance of a ministerial act, or he is excluding another person from the use and enjoyment of a right or office to which such other is entitled. In prohibition, the ground is error of jurisdiction. Discuss na natin yung error of jurisdiction. How about in injunction? What is the ground? Basically, it does not involve the jurisdiction of the court. In fact, if you go to your Section 3 of your Rule 58, nakasulat dyan from numbers 1 to 3, the grounds for the issuance of a preliminary injunction. So, ito ang kabuuan ng difference from injunction from prohibition and mandamus. Take note always of the ground, the respondent, and the rules that govern them. When are you going to file your Rule 65? Answer is not later than 60 days. 60 days from when? 60 days from notice of the judgment, order, or resolution. But we also said that your filing of motion for reconsideration is a sine qua non condition. So, you will be filing it within 60 days from the notice of the denial of the motion. E paano kung si attorney ay masyadong busy? Busy sa pagkikipag-date, nakalimutan. So, do you have a remedy? Can you extend? General rule, again, what did we say? The 60-day period is inextendable except if you have exceptional circumstances, and of course, it is always subject to the sound discretion of the court. Then you can extend the 60-day period. Where are you going to file your Rule 65? Answer, in RTC, Court of Appeals or Sandigan Bayan, and in COMELEC. So, kailan sa RTC? If the petition relates to an act or an omission of a municipal trial court or of a corporation board officer or person, then you file it in RTC. Court of Appeals or Sandigan Bayan, whether or not the same is in aid of the court's appellate jurisdiction. In Court of Appeals, if the petition involves an act or an omission of a quasi-judicial agency unless otherwise provided by law or these rules, and COMELEC if it involves an act or an omission of an MTC or RTC in aid of its appellate jurisdiction. So this is according to your Section 4 of your Rule 65. Can you file also in the Supreme Court? Kahit hindi naman nakasulat dyan sa Section 4 ng Rule 65, answer yes. Because if you're going to read Rule 56, Section 1, ano ang sinasabi dyan? Petitions for certiorari, prohibition, and mandamus may be filed originally in the Supreme Court. But if you are going to file it in the Supreme Court, you have to take note first of the doctrine of hierarchy of courts. Ano ba yung doctrine of hierarchy of courts? You have to relate it always to this concurrent jurisdiction or what they call coordinate jurisdiction. Ang coordinate jurisdiction is the power of the different courts to take cognizance of the same subject matter. So, even if the power of the Supreme Court to hear the petition for certiorari, prohibition, mandamus, take note that it is not an exclusive. It is shared by the Supreme Court with the RTC and the Court of Appeal. So, meron silang concurrent jurisdiction. And even if they have the concurrence of jurisdiction, it does not mean to say that ikaw party, since alam mo naman pwede palang i-file kay Supreme Court, hindi kay Supreme Court na ako, or ikaw si lawyer, sasabihin mo pwede naman pala kay Supreme Court na ako magfa-file kasi mas mataas ang masisingil mo sa kliyente. Ang sabi ng Supreme Court dyan, it should not be taken to mean that the parties have an absolute unrestrained freedom of choice of the court to which they will file their application or petition. Because in the doctrine of hierarchy of courts, there is an ordained sequence of recourse to courts vested with concurrent jurisdiction. So you begin from the lowest and then you move on to the next highest and ultimately to the highest. So from the RTC to the CA and then to the Supreme Court. So that is the doctrine of hierarchy of court. But are there instances wherein you can disregard the doctrine of hierarchy of courts and instead of filing in the RTC or in the Court of Appeals, you will directly file in the Supreme Court? Pwede ba yan? Allowed ba yan? Answer, yes. The doctrine of hierarchy of courts is not an ironclad rule, as there are exceptions. So what are those exceptions? First is if there are genuine issues of constitutionality that must be addressed at the most immediate time. Second is when the issues involved are of transcendental importance. Alam nyo to, may maraming cases sa political law or sa constitutional law. third is, these are cases of first impression. Pag first impression, ano ang ibig sabihin yan? No jurisprudence yet exists that will guide the lower courts on the matter. Fourth, the constitutional issues raised are better decided by the higher court or by the Supreme Court. Fifth is if there is a time element presented in this case. Sixth is you are going to review the act of a constitutional organ. Like for example, your constitutional organ or your COMELEC or the Civil Service Commission. So seventh is there is no other plain, speedy, and adequate remedy in the ordinary course of law. And last is it includes questions that are dictated by public welfare and the advancement of public policy or demanded by the broader interest of justice, or the orders complained of were found to be patent nullities, or the appeal was considered as clearly an inappropriate remedy. So these are the exceptions to the doctrine of hierarchy of courts. So what are the reliefs petitioner is entitled to? According to your section 7, the court in which the Rule 65 is filed may issue orders expediting the proceedings, and it can also grant a TRO or a writ of preliminary injunction. What else? According to your section 1 and 2, the court can also grant such incidental reliefs as law and justice may require, and it could also grant reliefs prayed to which the petitioner is entitled. That is according to your section 8. And it could also impose disciplinary sanctions for lawyers who patently files unmeritorious and dilatory petitions for certiorari. What is your prayer in certiorari? Again, what did we say? Your certiorari is a corrective remedy. Your objective really is you want to correct. In fact, in your certiorari, your prayer is you want the judgment be rendered annulling or modifying the proceedings of the tribunal, board, or officer, and you want to grant such incidental reliefs as law and justice may require. In your prohibition is a preventive remedy. Your objective is you want to prevent. That is why your prayer is, according to your section 2, you want that a judgment be rendered commanding the respondent to desist from further proceedings and to grant such incidental reliefs as law and justice may require. In your mandamus is you want to compel. That is your objective. And in your section 3, your prayer is you want that a judgment be rendered commanding the respondent or the court, the person, the tribunal, or corporation to do the act required to be done to protect the rights of the petitioner and to pay the damages sustained by the petitioner by reason of the wrongful acts of the respondent. But can you grant also damages in prohibition and certiorari? Answer, yes, kasi papasok siya doon sa granting such incidental reliefs as law and justice may require. So we'll go now to the acts or omission of MTC and RTC in election cases. So according to your section 4 of Rule 65, ano ang sinasabi dyan? In election cases, and that involves an act or omission of your RTC or MTC, and if you're going to file a petition for certiorari, prohibition, or mandamus, where are you going to file it? You will file it exclusively with the COMELEC. Hindi sa RTC, hindi sa Court of Appeals or sa Supreme Court, but in the COMELEC. COMELEC ha, take note of that, in aid of its appellate jurisdiction. Ano ba ang ibig sabihin ng in aid of its appellate jurisdiction? If a case may be appealed to a particular court, then said court has the jurisdiction to issue the extraordinary writ of certiorari in aid of its appellate jurisdiction. Sa next slide, mas lalo nyo itong maiintindihan. So for barangay officials, where are you going to file your election case? Answer is according to your section 252 of BP bilang 881. That is your Omnibus Election Code. You will be filing it in the proper MTC, Municipal or Metropolitan Trial Court. And If you do not like the decision or if the decision is adverse to you, what is your next step? You can file an appeal. Where are you going to file your appeal? Sa RTC ba? Answer, hindi. You will file your appeal in the COMELEC. Bakit COMELEC? What is your basis? That is your 1987 Constitution, Article 9. Very clear. According to your 1987 Constitution, Section 2, letter C, the COMELEC exercises appellate jurisdiction involving elective barangay officials decided by trial courts of limited jurisdiction. But if napansin mo that the MTC acted without jurisdiction or the MTC judge acted with grave abuse of discretion, can you file a petition for certiorari? Answer is yes. That is very clear according to your section 4 of Rule 65. And where are you going to file your Rule 65 or your certiorari? In the COMELEC. COMELEC in aid of its appellate jurisdiction. Bakit sa COMELEC? Again, what did we say? If the case is appealable to a particular court, just like in this case, from MTC decision, the next step is you appeal it in the COMELEC. Then, said COMELEC has also the jurisdiction to issue the extraordinary writ of certiorari in aid of its appellate jurisdiction. So, yan ang ibig sabihin yan. Kaya, ang filing mo ng certiorari is in the COMELEC. Take note that if you appealed the decision of the MTC to the COMELEC, the decision of the COMELEC in election contest involving municipal and barangay offices shall be final, executory, and not appealable. It is final, executory, and not appealable. So in that case, meron ka pa bang remedy? Wala na, because it is final, executory, and not appealable. But pwede ka pa bang mag-file ng other action? Yes. Answer is yes. That is according to your Rule 64. If you feel that the COMELEC acted without jurisdiction or there is a grave abuse of discretion, then you can file a Rule 65. But the rules that you will be observing is the rules stated in your Rule 64. So ito yung Rule 64 in relation to your Rule 65. You can file from the judgment or final order or resolution of the COMELEC. It may be brought by the aggrieved party to the Supreme Court on certiorari under Rule 65. But magkakaroon na ng difference sa period and other rules. So please take note of that. So for your municipal officials, where are you going to file it? You file it in the RTC. That is very clear according to your section 251 of the Election Code of the Philippines. And for the appeal and certiorari, again, the same also with the procedure in the barangay officials. So please take note. So bar exam question MCQ 2012 number 22 in election cases involving an act or omission of an MTC or RTC, a certiorari petition shall be filed with the Court of Appeals, Supreme Court, COMELEC, or the Court of Appeals or the COMELEC, both having concurrent jurisdiction. Answer is letter C, the COMELEC. Last slide, what is the effect if you are going to file an unmeritorious petition? Answer is the court may dismiss the petition. The court where the petition is pending may dismiss the petition. Sayang ang filing fees. So the court may dismiss the petition if it finds that the petition is patently without merit, it is prosecuted manifestly for delay, or if the questions raised therein are too unsubstantial to require consideration. And in case of the dismissal of the petition, the court may also award in favor of the respondent triple cost. So na-dismissan ka na, pagbabayarin ka pa. So triple cost, solidarily against the petitioner and the counsel. In addition to the triple cost, the counsel also will be subjected to an administrative sanctions under Rules 139 and 139B of the Rules of Court. Also, the court may impose other disciplinary sanctions for lawyers who patently filed unmeritorious or dilatory petitions for certiorari based on res ipsa loquitur. So this is your section 8 of the Rule 65. So this is the end of the video. Thank you very much for watching and have a good day.